like to welcome everyone here today for the session, the Appeals on Will session of the Court of Appeals of Indiana. My name is Scott Lee. I'm an assistant professor of political science here on campus. I'm also the chair of the Department of Criminal Justice and Political Science, the pre-law advisor, and the campus coordinator for this event here at IU East. We acknowledge and are grateful for the members of the Court of Appeals of Indiana who will be joining us shortly, for their staff, for the local judges, and the local and state government officials who are here in attendance with us today. We acknowledge our students, staff, faculty, and members of the community who are here. Thank you all for coming today. We also want to thank Dean Snyder of the School of Humanities and Social Sciences, the IU East Office of External Affairs, Campus Police, AV Support and Information Technology, Physical Facilities, and Media Relations for their support in putting on this event. So now, before the session begins, let me remind you of a few housekeeping rules. First, when the judges enter this room, it, in essence, becomes the courtroom. Therefore, no hats are to be worn, no talking. At the end of the session, there will be a question and answer period, but please, no questions about the case that's being argued. They will politely, give you a dirty look and say they can't answer those. So don't ask any questions about this case. But anything else about what the judges do and what it's like to be a judge and the process they go through, ask away. They're excited to answer those questions. We ask that you silence your phones and other devices. That tends to be one that we forget. So if we could do that. No pictures are to be taken. There is no recording of this session. Court staff will be recording it, and it will be posted on the court's website later. We ask that you find your seats. Once the judges have entered, the doors will be closed, and we can't come in or go out until after the session is over. So please do that. Finally, when the judges enter the room, the bailiff will ask all of us to stand, and we are to remain standing until we are told that we can sit down. So with that, they should be here momentarily.
All rise. Hear ye, hear ye, hear ye. The Indiana Court of Appeals is now in session. The Honorable Patricia A. Riley of Jasper County presiding, with the Honorable Melissa S. May of Vanderburgh County and the Honorable Leanna K. Weissman of Dearborn County.
Thank you all. This is a pleasure being here. Melissa and I both been here before, and Judge Weissman is one of the newer members of our court, so we're glad she could come along too today. We're glad to have the attorneys here. Mr. Hammerly, nice to see you. And who's with you today?
Julie Trida.
Good morning.
Good morning. Thank you.
My intern who remains a third-year law student.
Oh, great. Thank you so much. All right. And we have Kelly Loy. Loy. Thank you. All right. I think we're all ready to begin. If you'd like to start, Mr. Hammerly.
May it please the court, your honors, Ms. Loy, and my illustrious co-counsel, Ms. Trida. Your honors, if I may start by saying my client, Mr. Johnson, has been facing these charges since March of 2014, almost 8 years. And in a sense, I've used this analogy, it's almost like you've gone to a doctor and you're alleged to maybe have cancer and you have a biopsy and you've been waiting 8 years for that result. So we're thankful that we're here to get that result one way or the other. The issue here is it's not just Mr. Johnson, however, it's also the citizens of the state as it relates to the issue of whether the statute of limitations has meaning or whether it will be eviscerated. And then let me talk about that right away then as to the first count. We are asserting that 10 of the counts which are mentioned in the brief, and I won't rename them here unless you want me to, that they all have been filed more than 5 years after the offense charge, all of them. In that sense, they are violating the statute of limitations, all of them. And we would ask that on that basis alone, that they would need to be dismissed. The state has, and in that regard, I also must point out that these charges were filed in March of 2014. In January of 2012, the state became aware of these allegations. One of the alleged victims filed a complaint with the Secretary of State and with a Chesterton Police Department, pointing out security, which is noted in their brief on page 11, where they point out possible security violations. So the court was aware of this in January, or the state was aware of this in January of 2012.
So the state says that there's really no way for the victims in this kind of situation to discover that they've been defrauded until a maturity date versus the date that the promissory notes were signed. How do you respond to that?
I respond to that two ways. One, it's contradicted by one of the alleged victims coming forward within the time frame and reporting this. So that's one thing. But
are you referring to Mr. Cannell?
yes.
Okay, but that's not one of the ones that's outside of the statute of limitations, correct?
But he did become aware of it. And but more importantly, the Dvorak case, PTD case, clearly embraced the issue that you just brought up, that concealment was alleged to have been based on the fact of promissory notes, part of a security, maturing after a certain date, and that it delayed discovering of it. And the court specifically rejected that, finding that what this court needs to do is determine that when a person has a security that's issued, that it's a matter of public record to find out if it is indeed registered or if he's registered as a broker-dealer. The date that that's done is what is to be considered, and that's what PDT decided.
Okay, well, let's talk about that case
Yes.
for a little bit. Indiana does not recognize horizontal stare decisis, do they?
No, not that I.
So we are not bound by another decision of our court.
No, but not bound by it, but nonetheless, it is there to be followed if possible.
Right, correct, it is. Now,
has
the
meaning.
cases that that case relied on, it's referred to as two different ways. One, Dvorak, and we may use the word incorrectly, but I know on Westlaw, it's something else.
Right.
The two cases that Dvorak kind of based its decision on weren't involving any kind of securities fraud, were they?
Not that I don't believe so.
Okay, one was something involving a time, an exact time and space where you can, like an accident or something like that, where you can say that this is the time when this happened. Isn't a security, and I understand we're going to get into the issue of security a little bit later, but isn't this a little different zebra rather than a horse?
Well, I understand what you're saying, but I would say that no, that it's got to be that you can check a public record to see if it has been registered. You can check a public record to see if a person is registered as a broker-dealer. So there's a public record there to be seen. And what basically, in embracing Dvorak.
So the onus is on the victim then?
Well, no, the onus, it would be public knowledge. It wouldn't be the onus on the victim, it would be public knowledge. It would be, the public would understand that.
So how do we deal with these crimes that aren't immediately apparent? Let me give you an example. Say I give you a $100 bill that's counterfeit, and you don't try to spend that for 10 years and then discover that I have passed you a bill that was fake.
Sort of like practicing as a criminal defense lawyer, but go ahead.
So when does the statute of limitations begin? The moment that I hand you that bill, or the moment that you try and spend it 10 years later and discover it's a fake?
I would say the moment that they hand you that bill, because that you sat there and waited and held on to it for 10 years. And
It was a good counterfeit.
that-
You didn't know it was counterfeit until you tried to spend it.
That's true. And it would be the date that would run would be the date that it was handed to you, I would say. But I understand what you're saying, that there could be, well, let me put this, the exception with securities is that there is no public requirement that the person register that security, or that person register that $100 bill that date. As with securities, there is that requirement. And it's easy to check and see. But let me put it this way.
Well, let's go back just a second on that. The trial court order found that argument kind of perplexing as far as the dealer-broker thing, because whether or not he was registered or not could have been determined by the victims or the state to see if he was registered. But if he wasn't required to be registered, then how would they be able to figure it out?
Well, I understand what you're saying and what the argument that we're all wrestling with. But the issue here that I would go back on is that in this case, with the state became aware of securities violations allegations in 2012. Now, I understand whether whatever standard is applied, the fact of the matter in this case, the state became aware of this, and by their own brief, they say they began an investigation in 2012. They began their investigation. So once, regardless of whether we accept PTD or not, whether we accept Dvorak, whether there's exceptions, here the exception is that the state knew and began an investigation and still waited 2 years to file charges.
Does that matter, though, with tolling?
I'm sorry.
So as far as the way that tolling works,
Right.
does that matter? Because if a statute of limitations is tolled, it begins to run upon the date of discovery, correct?
Yes.
Okay. So what do we make of the fact that the state still had some time to file within the statute of limitations but didn't do so? Is there any legal import to that?
Yes, there is, because the state here, first of all, the statute of limitations, you've got those 5 years. The state became aware of this, of the securities allegations within those 5 years, and still did nothing. They waited over 2 years. So why did the state wait when they were aware of security violations?
Well, I'm concerned about that as well, but how does that impact our analysis of tolling? Because the way tolling works is the moment that if you've concealed something, the moment you become aware of it, the statute of limitation begins, correct?
Right,
So
right.
that's a problem for you, right?
Well, yes. I mean, if this case came down to that, yes. But the exception here is what you just said. Let's assume that you put tolling as the standard. Let's assume that you put tolling as the standard. But here, the exception is if one cannot say that the defendant engaged in concealment, that the tolling was to be applied, when the fact is the state became aware of it because one of the alleged victims reported it. And so that in one of the alleged victims reporting it, they were put on notice. So the tolling thing, we can get into a legal discussion of that, but here the exception is that the state still bears the burden. The statute of limitations was running, and they still did nothing for over 2 years when they
So
became
just
aware
to
of it.
that victim, just to that one victim?
No, they in their brief on page 11, they stated that they were aware of possible security violations. So they became aware and began their investigation then, and still did nothing. And so that the statute would not be told at that point because they became aware of it, and still waited, and these charges would need to be dismissed for those reasons.
What is the action against the state, for example, if they file too quickly, and the defendant then sues them for not having enough legal basis to file. Is there something like that?
I don't believe so.
Okay.
I don't believe so. I think here that for me, in looking at this and understanding what all of you are saying, that we're looking at something where one of the 7 alleged victims that came forward was aware.
So they should have filed and then just amended later, which
They
is
could have done.
basically what they've done.
Well, we can get to that in a second. And yes, I don't want to.
So there's no
I don't
malicious,
wanna
That's another
say-
can of worms.
I don't
no
wanna say-
malicious prosecution issues going on here.
No.
Okay.
No, I don't want to say it. I agree with you, and you say, okay, sit down and don't argue the second part of this, which you may say anyway. But at any rate, the importance is what they became aware of, and what you decide the meaning of that is.
So the first report came in January.
Yes.
He was interviewed in September.
Right.
And the statute's still not run at that time. And the state's continuing to find other victims and interview them before the statute of limitations is
Right.
run. Okay.
So, but they were investigating securities violations, so that I would say that they knew about this and didn't file, and so that the dismissal would have to be granted. That's where that's where, on that argument, if I could go into the knowing.
Sure.
The issue on knowing is clearly, it's the mens rea requirement of this charge, and the state did not allege it. And the state concedes that in moving to have it amended. Our first argument is on that all of the counts need to be dismissed because knowing was not stated, an essential element. And as what do we have here? It was Justice Bohm stated in his concurring opinion in Health Script, an information must state the crime charged with direct and unmistakable terms, and any reasonable doubt as to the offense charged must be resolved in favor of the accused. I would hear, by not alleging knowingly, they did not allege a crime, and the reasonable doubt is that these charges would have to be dismissed because that it's not a crime, it is a civil complaint. That's it. And so on the basis of that,
So how did the trial court abuse its discretion in allowing the state to amend to add the mens rea element?
well, then we get to that on whether whether they can move to amend. But the issue here is this: it's whether it occurs against logic or contrary to law. Whether it's an abuse of discretion, and we would say that it's abusing it because you cannot amend. You can amend a criminal charge, but you can't amend a civil complaint, thereby turning it into a criminal charge, and that's what you have here. You have a civil complaint, period, and if the motion motion to dismiss that based upon it knowing isn't alleged, it has to be granted. Now, again, the state is saying, well, okay, all right, let us amend this thing, Mr. Hammerly, and sit down and go away. The issue here, though, is that it's not an amendment. They're saying that, but it is, you can't amend a civil complaint. You're filing a new charge.
Could the
and-
state dismiss and refile?
If they do, they're violating the statute of limitations. If they dismiss that civil complaint and now file for the first time criminal charges, it would be in violation of the statute of limitations by any definition.
Unless the statute of limitation has been told by concealment.
Unless you're going to, yes. But then again, I would say that has no meaning now because they were aware of everything. And let me put it this way: the state has alleged that when they filed their 3 extra counts in 2015, that there's a statute above that they cited that contains knowingly, if you read the statute. But what that means is, I would ask this: the state became aware in 2000, by their own definition, the state, when filing that, became aware that the knowing requirement is the mens rea requirement of this charge. They became aware of that. And furthermore, in 2016, they then filed amendments. But the amendments did not address the knowing. Now, 8 years later, they're saying, okay, let us file this amendment now. No, you knew about it in 2015, and you did nothing when you amended in 2016. Now, it's contrary to law, it's against logic, and the issue here is that the prejudice flowing to the defendant, who now must go back 15 years possibly, and the prejudice flowing from memory, trying to recreate all of that, when the state could have even tried to do this back in 2015 and 2016 and didn't. It's staggering.
What
And
about the statute that says knowingly that he's charged with?
excuse me.
He's charged with a statute that says knowingly.
Well, they only noted that in filing the 3 additional charges. They didn't.
In 2015.
Yes.
So the charges that were filed prior to that didn't even have the statute under which he was being charged?
No, they didn't list that, is my understanding. They've been relying on the fact that it was only listed in filing the 3 additional charges. However, listen, in the health script case, that you cannot expect a defendant. I mean, when you have to allege elements of a crime in the information itself, you cannot sit there and say, well, all right, it's not alleged, but there's a statute on top that you can go and you can research that statute, and you could find by that research that you can have knowledge that it's knowingly. But that was rejected. That was analyzed, and that very principle was analyzed in health script, and rejected. And it should be rejected here. The only way that has meaning is that the state would know what that statute says because they filed it. And they became aware of it way back 8 years ago, and it would be an abuse of discretion now and prejudicial to allow them to amend. Beyond that, I would reserve whatever time I have left for rebuttal.
5.
Do you have any questions?
No,
Thank you, Mr. Hamlin.
Yes, Your Honors.
That's excuse me, that's the 2015 one. Right?
No, this is the second one. This is the original.
Okay. Thank you. You begin.
May it please the court. The state charged Mr. Johnson with 17 securities violations involving 7 victims committed over a 6.5-year period of time. The sale of securities is a heavily regulated field where both federal and state authorities place strict rules and requirements on individuals who choose to engage in the business of investing other people's money. Those regulations place the utmost importance on the circumstances surrounding the offer or sale of a security to promote safe investments and to protect the public and unwary investors. In this case, as alleged in the PC affidavit, Mr. Johnson admitted that he ran a business where he solicited investors and took their money. Whether these transactions are done illegally is an issue for trial. At this stage, this court is only tasked with determining whether the charging information and probable cause affidavit sufficiently notify Mr. Johnson of the charges, the conduct of which the charges are based.
What about the statute of limitations issues? Why did the state wait so long? Is that revealed in the record?
As far as from the point in time that Mr. Nutella came to the Secretary of State's office?
Yes.
Okay. So at that point, they began what ended up being a 2-year investigation into Mr. Johnson's activities.
Wouldn't it
This
behoove the state,
revealed-
though, when you're that close to the statute of limitations, to get your charges filed so you don't have to worry about this very thing that we're here talking about today?
So Mr. Nutella's charges were filed within the statute of limitations. So when he came to the authorities, they were charged within the 5-year period of time and is not part of the motion to dismiss. That subsequent investigation, which as noted in the probable cause affidavit, revealed a number of other victims. Those victims that were prior to Mr. Nutella, so back in 2007 and 2008, were revealed during that investigation. So the investigation, although it's not in the probable cause affidavit, usually requires an enormous amount of looking through institutional banking records and trying to determine when money came into a particular account and if it went out of an account and where it was spent. And so
Mr.
that
Johnson has made an argument that that they're exempt from the registration requirement of the Securities Act because all these people were known friends or relations of him. Is that correct?
So the exemption for a particular security is statutorily based, and it is something that the defendant has the onus to bring forth at the trial. So whether or not an exemption would relieve Mr. Johnson of registering the security is a question of fact that would be decided at trial, and not whereas here we're trying to determine whether the facts were sufficiently pled in the information. And
Okay,
in that,
but I'm a bit perplexed by the interlocutory order that has that listed as for our review. Whether the trial court abused discretion when it deemed his motion to dismiss because the financial instrument was at issue was exempt.
Yes, that was an issue that Mr. Johnson raised before the trial court. And the trial court did not abuse its discretion by saying in the charging information.
Okay, but what if we say he did abuse the discretion? Isn't that a question of law?
No, it is not, Your Honor. The particular issue is whether there were exemptions. That is a question of fact that is part of Mr. Johnson's defense that he would then raise at the time of trial, and not in a motion to dismiss as to whether the information or the affidavit is sufficiently pled. The exemptions.
Okay, but I'm still complexed about what are we supposed to decide on an interlocutory order when it is listed as such, whether the trial court has abused its discretion. Don't we have to rule on that?
Yes, and the trial court did not
What
abuse
if we
its
say
discretion.
that he was right?
That Mr. Johnson was correct?
Right.
If this court finds that the exemption is no longer a defense and is no longer a requirement that the defendant,
raising the
that would be
exemption.
incorrect.
I'm confused. Whether the trial court abused its discretion when it denied his motion to dismiss.
Correct. That's the standard of review for the trial
Right.
court's decision.
So if we say the trial court was wrong, then the exemptions would be correct and it wouldn't go to the trial, wouldn't go to the jury.
First of all, the trial court was not wrong. That was not an abuse of discretion. The statutes clearly
I understand,
say,
but isn't that something we have to decide?
if this court finds that the trial court made an error in saying that the pleading was insufficiently pled on the exemptions, then the state has requested that they be able to amend the information to include the necessary information.
Okay, and so
that
now
that
we
does
say
not prejudice the defendant.
I'm talking. So now we say that they were not, that you cannot amend. Now what? Isn't that something we decide, whether you can amend the information?
If this court finds that the trial court abused its discretion.
Exactly.
And that it would prejudice Mr. Johnson for an amendment to be made, then yes, this court would decide. But that would only be relevant to the charges that require that the securities, or that charge Mr. Johnson with selling securities that were not registered. So it would not affect the broker-dealer charges, nor would it affect the securities fraud violations.
Can we talk about the securities? Why do you identify those as securities?
Your Honor, the probable cause affidavit explains that they are promissory notes, and that was part of Mr. Johnson's scheme, is that he engaged in the offer or sale of promissory notes. The statutes clearly define what a security is, and that includes a note. And there are several cases that show that promissory notes are in fact securities.
Is this a question for the jury? As far as, you know, sometimes we have the legislatures instructed that the judge is to make a predetermination. I'm thinking harmful dissemination of minors. I don't see that in the statutory scheme, that the judge would make a predetermination that these are securities. So isn't that a question for the jury, not for us?
Correct. I think the state sufficiently pled that the securities are at issue, and that the type of security is a promissory note, and that's sufficient for the pleading. It would be determined at trial what the evidence showed as far as whether or not it was in fact a security. So you're correct, Your Honor.
Thank you.
Yes. The statute of limitations didn't, even if we assume that it was told up until the point the securities division learned of Mr. Natella's complaint, even if we accept the 2012, the charges were filed in 2014, and that was well within the 5-year statute of limitations. The tolling, the positive acts of concealment on Mr. Johnson's part was part of an overall scheme in which he engaged in not only a shell game, but also a quasi-Ponzi scheme.
So is the concealment the failure to register, or is the concealment the structuring of the notes to mature outside of the statute of limitations?
In this case, Your Honor, which is different from PTD, is that there are securities fraud charges alleged, and there is an overall fraudulent scheme that Mr. Johnson engaged in to hide or conceal the fact that the initial transaction of offering or sale of a security was done illegally. That would include the registration and that the registration requirements, and it would also include the misrepresentations, the omissions, and the fraudulent
So it's
activities. Correct. So the fraudulent scheme to hide the fact that that transaction was illegal was Mr. Johnson using this equity trust, which is a self-directed IRA company.
So concealment usually results in a positive act. We've always found that it's a positive act by the defendant. How is the failure to do something a positive act?
Which this court does not have to decide that merely failure to inform the investor that the securities were unregistered and the broker-dealer was unregistered. However, a broker-dealer has a duty, a positive duty, to inform an investor at the time of the offer or sale as to the registration requirements and whether those have been met. So in this case, what the positive act is his decision not to inform the investors of information that they are guaranteed to have and
So his
should
positive
have.
act is his inaction.
Correct. It's his decision not to do something that he is obligated to do by duty. But this case also has the overall scheme in which he was trying to hide what in fact he was doing.
But you
And
said that was his duty. That would only be if he registered as a broker-dealer, right?
The duty is only required by broker-dealers, correct. And the state has alleged that he is acting as a broker-dealer. So Mr. Johnson used the equity trust, the self-directed IRA, as a custodian.
If he
so
wasn't
that
acting as a if he wasn't acting as a broker-dealer, what was he acting as? I mean, what is the term that would be used?
If he wasn't acting within the definition of a broker-dealer, then the state would not be able to charge him with those particular acts. If he's not acting as a broker-dealer, Your Honor, I represent that he is just merely a fraudster, and that's how he is acting. He is trying to separate a person from their money,
But you
and
didn't
that's what
charge
he
him
did.
with that.
I'm sorry, Your Honor?
You didn't charge him with fraud.
Yes, there are 3 counts
Okay.
of fraud that concern all 7 of the victims.
Okay.
And that's counts 13 and 14, I think?
Correct, and 17.
Okay.
Correct. So the charge regarding the broker-dealer would only be if he was acting as a broker-dealer, then he would be required to register. And of course, if he wasn't acting as a broker-dealer, which would be an issue for trial, which he may be found not guilty of, he would not have been required to register, and he would simply be somebody looking to separate a person from their money. And that's what he successfully did.
Okay, I want to go into the knowingly issue
Yes.
a little bit and talk about the informations that were filed. Let me find them right here. Hold on. Technology is a wonderful thing when it works. So the original informations were filed on March 14th, 2014, is that correct?
2014, correct.
And let's just take count one, for example, where it says count one, securities registration violation, Class C felony, IC 231931. Is 231931, is that the statute that has knowingly in it?
No, Your Honor.
Okay, which is the statute that has the term knowingly in it?
So for Mr., if we just look at the first one.
Right.
That would be 2319.58. So all of the securities laws are under the 2319, Article 19 umbrella. And the statute that refers not only to the mens rea, the knowingly, but also to the fact that it is a felony, is 2319.58. And Mr. Johnson was well aware that he was being charged with criminal felonies. And those two, the level of felony and the mens rea, can be found in the same statute within the securities laws in the Indiana Code.
Well, I kind of understand. I understand your argument because you want it obviously to be covered, but the count one doesn't say that. I mean, I know that count one isn't one of the ones to be dismissed. Let's look at count three, which one of these is. And 2319.58, nor the general 2319 isn't listed. Do you see that as a problem?
No, Your Honor, for several reasons.
Okay.
One is Mr. Johnson's charges span the scope of amendments that were made to the securities laws. And prior to the First Amendment, under which some of his crimes are charged, there did not include a knowingly. So the history of the statute, the word knowingly was not included when it described what the level of felonies were. Before he was charged, it did change to include not only the word knowingly, but also the level of felonies in the same statute. And although the initial charges that he was filed do not include reference to that specific statute, the crux is that whether he was put on notice that would be the mens rea. And that answer is yes. And we know that as early as 2015, when the state amended the charges to include one more victim with both registration violations and security fraud, they did refer specifically to 2319.58.
But they still didn't say knowingly in the charging information.
The word knowingly, correct, was not in the charging information.
Is it in any of them?
No, the word knowingly is not. The reference to the statute with knowingly is.
But
And even,
an amendment cannot be made for a substantial part of a criminal information. You'd have to dismiss and refile.
an amendment can be made, Your Honor,
Not
if
for
it does not
substantial.
prejudice the
It's an
defendant.
element. It's an element of the crime.
An amendment can later be made so long as it doesn't
Not for
prejudice.
an element. How about
Yeah.
it's a substantial part of the
Yes.
information.
Correct, Your Honor. And as far as the issue is whether he was put on notice as to whether that was
Isn't
the
that
mens rea.
just for civil cases and not criminal?
No, Your Honor. Here, time is not of the essence. So the state would argue that the time and the mens rea were sufficiently pled to the extent that the amendment referenced the statute that also includes knowingly. And so from 2015, he was on notice. An amendment to the statute,
Does that mean he
even if
wasn't charged? If he's just on notice, then he's not charged.
no, he was charged, Your Honor. He was fully aware he was being charged with criminal violations.
What case says that's the test for criminal information, that you just have to be aware or on notice?
That is the test for whether the state has sufficiently
Where does
pled.
it say that?
There are several cases, Your Honor, cited in our briefs, and that we also cited before. But Woods would be one case.
Well, I'll look it up in the brief.
Is it Woods? Is that 980 Northeast 2nd, 439?
Correct,
Woods.
Your Honor. I'd also direct this court to Convy State, which is case that the state filed in their brief regarding knowingly not being included even in the jury's instructions.
Can I switch you back just for a brief second on the statute of limitations issue?
Yes.
The best part of your argument is that the concealment occurred because he structured these so that the folks would not figure out they had been defrauded within the time, which it's a 5-year statute of limitations.
Correct, Your Honor.
But the probable cause doesn't seem to support your case. It looks like he made a promise to Hunt that she'd have her investment back in 1 year. And she made Wrigley a period, he said he'd return the investment in 3 years. Deal was a 2-year turnaround. We don't know about Thornton, and Watson was due just under 5 years. So how does that impact how we should resolve this case?
So the maturity date is it has legal significance for many reasons, but one is that the investor is not necessarily looking for their money to be paid in full or what was promised to them.
But you're arguing
until that
concealment
maturity
based
date.
on the fact that they could not have figured this out within the statute of limitations, but the facts don't seem to support that.
Both, Your Honor. Both that the maturity, putting a maturity date in the promissory note was a positive act, and number two, he chose what date that would be, and for whatever period of time that was told the investors.
Wasn't that pretty stupid? I mean, shouldn't he have done a 5-year maturity date if he was actually trying to evade and conceal this past the statute of limitations? Why promise something for a year or 2 years? Why not structure it out for 5.5 years?
I think he had the opportunity to do so, Your Honor. But even for a year, the investor would not be on notice that they would not be receiving their money back. And so it's only upon that maturity date and when they haven't been paid that they realize that there's a possibility that they may not get their money back. So it's only part of the overall scheme, Your Honor. It is not.
But we need to look to see if the defendant made a positive act with the intention of concealing something so that they wouldn't be charged with a crime.
Correct.
So
and in
he's a pretty dumb criminal, or there's not the appropriate mens rea to conceal the crime.
the concealment is both the shell game that he engaged in and the Ponzi scheme. So for many of the victims, even once the maturity date came, he told them, I don't have your money, or there's been a downturn in the market, my investment is not doing well. He actually paid some of the victims partial payments, and so those have all been held to be positive acts of concealment. I would liken this case to not only M.A. v. State, but also Curzan v. State and Woods v. State. All of those had to do with fraudulent charges or misappropriation of funds.
Thank you, Ms. Lowe.
Thank you. My
Thank
time is
you.
up. Thank you.
Let me just comment on positive acts of concealment. What we're talking about here is having promissory notes to be paid off over a period of time is a positive act of concealment. Think of what that means to our business community. Think of what it means if you have a mortgage. When you have a 15 or 30-year mortgage, that's a positive act of concealment because of the length of time by itself. On a car loan, because you're paying it off in 3 years, that's a positive act of concealment. We have students here with student loans. They're going to pay off over a number of years.
Yeah, but on all of the loans you're talking about, there happen to be monthly payments that are due. And if those people don't pay those monthly payments, that's a problem, isn't it?
Well, it is, except for the fact that you've got student loans where you're not paying it in quite some time.
Right, but once it starts, I mean, you have to pay it or else you get in trouble.
Well, then, agreed. But you've still got that what you're asked to do is reject PDT and Dvorak. What you're asked to do is to find that being paid off in a period of time as a positive act. and we are urging you to adopt that reasoning of that case here. But the issue here is that I want to just leave this. This whole thing is that he's put on notice about the knowingly. Look at all the charges. In the body of the charge, that statute, that doesn't say knowingly on any of it. If you look in the body of the charge at the bottom of it, it doesn't cite a statute that uses the word knowingly. Up in the right-hand corner on 3 of them, filed on 2015, in the right-hand corner is cited another statute. And what they're saying is that put him on notice. And looking at what HealthScript talked about this, you cannot expect, under the obligation of the state, to file charges that spells out in meaning the elements of the offense in the body of the information. You cannot allow the state to escape that by citing some statute in the corner and saying, well, the defendant was aware of that. No, he wasn't. And HealthScript completely attached that. On the other hand, here is the thing I want to fall back on. Here's what we have. We have charges filed in 2014. We have these new charges filed in 2015. The state then moved to amend in 2016, adding concealment to 4 counts. The concealment didn't allege anything other than paying them off over a period of time. And so they now wait. And before that, who was aware of the requirement of knowingly? The state. The state put that statute up there. So they're aware in 2015 that they had an obligation to do that and did nothing. They did nothing. And now is it an abuse of discretion for the court to say, 6 years after they already moved to amend, 6 years later, I'll go ahead and do it now. We're going to legally allow you to do that. That's contrary to logic. It's prejudicial to the defendant, where he's talking about trying to defend this, if forced to, 15 years or more, 10, 15 years in the past, all because of the delay here. One last thing. We filed this motion to dismiss. It sat there for 3 years before the state responded. 3 years, the motion to dismiss hung there, and that part of the motion was ignored. That defies logic and common sense. We would ask you to grant our motion. Thank you very much.
Thank you, Mr. Hammond.
Thank you.
Thank you both for spirited advocacy. It's what we like to hear, and it helps us ask questions, and so that will further our deliberation. Right, now we're going to go into recess, and we'll come forward and answer any questions you may have, except about the case, which is what you want to ask. So we're in recess.
All rise. This court is now adjourned.